SJC-11967, Commonwealth v. Thomas J. Gerhardt.
Good morning, Ms. Jacobstein.
Good morning, Your Honor. Rebecca Jacobstein for Thomas Gerhardt. If this court accepts the trial court's findings, we win. Mr. Gerhardt's position must prevail on the fact that the police may not testify as to the administration of field sobriety tests in the operating under the influence cases and cases of marijuana use, and an expert is needed to explain to the jurors the correlation between drug use, physical characteristics of marijuana use, and how that would impact your ability to drive. Specifically, what the court found is that there is no scientifically established correlation between field sobriety tests and impaired driving in the case of marijuana. There are no physical characteristics that permit an inference of impaired driving due to marijuana use. And a layperson does not have sufficient understanding of marijuana's physical manifestations, how those physical manifestations impact someone's behavior, or marijuana's impact on driving ability in general.
What if a police officer did field sobriety tests, maybe including the finger-to-nose test and other tests, and then that police officer at trial testified as to his or her observations? Could an expert witness then come in and opine, correlating some of the deficiencies that may have been observed into an opinion?
If the police officer testifies, I asked the person to stand on one leg, and this is what happened, certainly. I don't think that they can testify that it's a test. I don't think they can testify as to cues or pass-fail, because that gives an aura of scientific validation of a test that doesn't exist.
Well, can you do that in an OUI case, though? Operating under the influence of alcohol? No, defense attorneys don't object for many, many reasons when the prosecutor said, did he pass or fail the test? But if they do, that objection is going to be sustained by most judges. So it's not really about pass or fail. It's about, is this a brick in a wall? And it's important to differentiate in this entire discussion the difference between the admissibility of evidence and the sufficiency of the evidence.
I think that if an officer went up and said, I asked the person to stand on one leg and they couldn't do it, and then an expert testified that the failure to stand on one leg had the following meanings, assuming you could find an expert to testify as to that and there was sufficient foundation, that would all be admissible.
Okay, let's play it out a little bit. We're at trial. The officer testifies that the defendant was asked to exit the vehicle and that in doing so he stumbled when he walked out. He appeared unsteady on his feet and his eyes were glazed. Admissible?
Of course.
Okay. Then he says, I asked him to stand on one leg and he could not do it for more than 10 seconds. Admissible? It's
admissible if there's going to be an expert that explains how to correlate that fact to the impaired driving. Okay,
but you don't say that he stumbled when he left the car is admissible only if it's contingent upon an expert testifying to that.
I think the reality is that if the expert doesn't testify, the evidence is insufficient.
What if he stumbles and he says, oh my goodness, I just had 5 joints? Do you need an expert?
You still do.
You still do?
That's the law in Massachusetts. The appeals court has found on multiple occasions that evidence of drug use plus erratic driving is insufficient without expert testimony on how the drug use and the amount of the drug use impacts the driving.
Well, we'll stay in Massachusetts and not talk about, as you were. We won't talk about Pennsylvania or Nebraska yet. But there's a number of rescript cases from the appeals court where, among other factors, field sobriety tests went into the equation of whether or not there was sufficient evidence.
That should have been objected to, and that should have not happened. because there's no correlation between field sobriety tests in, I can't really speak to other drugs because I did not look closely into other drugs, but in marijuana cases, there's just no correlation. Because, and this, I'm going to harp on this because I found it confusing. Field sobriety tests don't test for driving impairment. There's kind of a conception, at least I had a conception, that if you couldn't complete the test, then you can't drive. But there are many reasons you can fail these tests. Apparently, a lot of people just fail the tests. But there's medical conditions. You could be overweight. There's a variety of reasons. It's what the studies to validate this for alcohol have shown is that if you fail these tests, that means you've used a certain amount of alcohol, and there are separate studies that have shown that amount of alcohol means you have impaired driving. But there is nothing in that for marijuana. Marijuana, you don't know. First, it's not correlated at all to horizontal gaze nystagmus. Several studies have found it's not correlated to walk and turn. There are a couple of studies that found that it's not correlated to specific cues on the walk and turn. So if there's 9 cues on walk and turn, maybe like 3 of them don't correlate to marijuana use. And so if you fail on that, it's not going to be due to marijuana, according to those studies. And the one-legged stand, it does correlate to marijuana use. But you have to fail 2 of the 3 tests to fail the field sobriety tests. But more importantly, it only shows that people who use marijuana can't stand on one leg. It doesn't say that only those people who have used enough marijuana to have impaired driving can't stand on one leg. It's just anyone of any amount. And then there's the problem with the false positives, the chronic marijuana users who tend not to be able to stand on one leg.
That's
anyway.
all of that's true in operating under the influence of alcohol cases as well. Somebody hasn't had their insulin.
Right, so, I mean, that's, the reality is that there's always those other reasons available. But the point here is that in alcohol cases, they have shown a correlation, and it's due to the way alcohol soaks into the brain versus the way that marijuana impacts the brain.
Well, let me ask you, and you concede, and that's the district court judge found, that marijuana use can impair driving, right?
Yes.
Okay. Now we're talking about what is admissible and what's fair to be played in front of a jury. And you also tell us that the one-legged stand turn does correlate to marijuana intoxication.
Just use.
Just marijuana use.
There haven't, at least I am not aware of studies that say if you use this much marijuana and you're not impaired to drive, you can pass the one-legged stand test. And then if you use more marijuana or you're impaired by marijuana, you can't pass. The studies just show that if you use marijuana, you can't pass the test. And there's no correlation to THC concentration in the blood.
But it would show at least use of marijuana.
Certainly.
That coupled with driving behavior and other observations, fumbling for wallet, all those classic signs, would that be enough for sufficiency?
That's the problem, is that classic signs for impairment for alcohol aren't the same as classic signs for impairment for marijuana.
So if a police officer pulls someone over and they say, give me your license and registration, and they pull out the ice scraper, that's not a sign of intoxication?
It may be a sign of marijuana intoxication. It also may be a sign of intoxication by other drugs or by alcohol.
Or it could be a diabetes, or it could be anything, just like in an alcohol
Right, so
case.
it's certainly, I'm not saying that wouldn't be admissible. What I'm saying is that to call that an indicator of impairment, you need an expert. Because I don't know, and jurors don't know, in the context of marijuana, what that means.
They don't know in OUI cases. The jurors do not know, and they never hear, that these field sobriety tests have been studied to correlate to alcohol and to certain blood alcohol levels. And in fact, the district court model instruction basically tells the jury, here's what you've observed. You can take that into account and give it whatever weight you believe it should be entitled to. So if marijuana clearly impacts parts of the brain that control the ability to do field sobriety tests, then why shouldn't, I'm not talking about getting over the rail, I'm not talking about the required finding, then why shouldn't the officer be able to testify to the field sobriety test? This is what happened when I told him to do a nine-step heel-to-toe and turn and pivot, divided attention. This is what happened, and the jury will do with it what they do with it, assuming there's enough bricks in the wall to get over the required finding beside the field sobriety test.
So they're not told that it's a test, and they're not told that they're passing and failing. All they're doing is saying, I asked him to walk and turn in a certain way, and he couldn't do it?
Right, take a nine-step heel-to-toe, the person never went heel-to-toe, did 5 steps and fell over, and you tell the jury that.
You can tell the jury that. What you can't say is that the failure to touch the heel-to-toe is considered a cue of failure.
Can you do that in an OUI case?
I think you can.
Over objection?
I think you can. Because
Really? That's been Dalbert, Lanigan, or Fry general acceptance tested. Testing error rates, peer review publication standards, general acceptance in the scientific community tell us that you passed or failed that field sobriety test?
some courts have found you can't say passed, failed. Other courts have found that it passes the Daubert-Lanigan-Fry test. So yeah, those allow it. But I think what's more important is that, again, it's not about that being admissible by itself, just the observations. It's about allowing the jurors, first allowing the police officer, but then also about allowing the jurors to come to a conclusion based solely on that without an expert to explain the symptoms of marijuana use.
So,
Ms. Jacobson, go ahead.
Please.
I'm curious about what role is left for police officers in a marijuana impairment case. Is there any role for police officers given the judge's findings about the lack of correlation between the standard field sobriety tests and impairment? What can a police officer do now under the judge's findings?
I think what the officer's job is to, if a prudent person would think that they were committing the crime of OUI on anything, marijuana, alcohol, would be they could arrest the person.
No, I'm sorry, I
at
wasn't
trial,
clear.
is that what you mean?
Yes.
Okay,
yes,
I'm sorry.
yes.
So at trial, it's their job to explain their observations. Because their observations are important.
Okay, but
not by themselves.
But if the judge has decided that there's no correlation between these observations and impairment, is that relevant to any issue in the case?
Well, he wouldn't be able to testify to the horizontal gaze nystagmus anyway. With respect to the one-leg stand, he would be able to testify to that insofar as he would be able to say, insofar as an expert would be able to say that demonstrates marijuana use as opposed to impairment. And then with respect to the walk and turn, I think that he might not be able to testify to those. It's possible he can't testify to anything about that at all because there is no correlation. But at least with the specific clues, it's hard because if a person just walked from here to there, of course the police officer could testify this is how they walked from here to there. But whether they walked from here to there given certain instructions, I'm not sure that without an expert that they can testify to that. I think that there's only a foundational requirement, the foundational requirement of relevance is only met if there's an expert that is then willing to say that this has some meaning. I think in and of itself, it can't come in. And then I think if it does come in by itself without an expert testimony, it certainly doesn't meet sufficiency.
And it can't come in because it's not relevant, or it can't come in because it would be viewed by the jury as a test and would be unfairly prejudicial, which would exceed its relevance. Which
Both.
one?
it's not relevant because it's not reliable.
But
And-
what's, if the person walks out of the car and is unsteady, you say that clearly comes in. So what's the difference between he left the car and walked unsteadily versus I asked him to walk steadily and he could not?
I think the difference is that he, at one point, can't do what anybody can do versus now he's, I think you're right. I think it's the fact that it's viewed as a test because the jurors know about field sobriety tests and they're going to know that, you know, that if you can't do them, that means you're under the influence.
Is it fair argument for a prosecutor in his or her closing to say to the jury, this person was impaired and you should find this person guilty because they couldn't even get out of the vehicle and walk to the back of the cruiser? They're stumbling all over the place.
I think that it might be sufficient in extreme cases of erratic driving and extreme cases of physical impairment that maybe, I don't know, and assuming there's other evidence that it's marijuana versus another drug, that maybe could be by itself sufficient. But in the other cases where, it's little things or the impairment is for not using a turn signal, then you're really, I think you've really got to have a good chunk of erratic driving plus a good chunk of inability to do everyday stuff.
So we're supposed to come up with a standard that says a good chunk?
No, I think if you wanted to make a bright line, I think the bright line would just be that you have to have an expert to correlate these things until enough of society understands how marijuana is impacted and isn't.
And I think it's a fair point because we're dealing with studies, and studies will change and the like. This is a moving target in many ways.
I think that's right.
Okay, if I could just make sure I understand the world according to Jacob Stein.
Very few people do.
In your, we don't need to go the entire world, just this corner of it. In your world, it would be in all but the most exceptional circumstances, the evidence would be insufficient without there being an expert.
That's correct.
Okay, and we haven't gotten into how you would need to qualify the expert, but we're not going to have time to do that. You would say essentially that evidence of behavior and evidence of the one-legged test comes in, would be admissible.
As long as it's not clearly a test.
Right, I understand.
Right,
Evidence,
okay,
evidence of behavior.
Right,
But the
evidence
one test you would say is admissible, even though it may be seen as a test, is the one-legged test.
Right, because it correlates to something.
Okay, so that the one-legged test you say comes in, and an observed behavior comes in. And of course, statements made by the individual regarding use of marijuana, and I assume the smell of marijuana and everything else, all of that would come in.
Correct.
And the Commonwealth then would be, but I gather you're saying the lay opinion of the officer would not come in, am I correct?
Right, because the problem with that is twofold. Is one, it's not particularly helpful to the jury to hear that the officer thinks that he's high, because one, they can't, if they don't have a general understanding of what the physical characteristics of being high are and how that correlates to driving, then all they're doing is they're speculating as to what that means. And also because they can't independently assess it based on the officer's testimony. In alcohol cases, the officer could say, I observed these behaviors and therefore I thought that he was drunk. But the jury could know in their own mind, they could assess whether or not it's reasonable for him to have come to that conclusion based on the observed behaviors. But in marijuana cases, they can't, and they really would just have to defer, and that would turn over the determination to the police officer.
Okay. And going to Justice Gaziano's point, I gather you also would agree that if there are indeed field sobriety tests or adaptations to the field sobriety tests which turn out to be correlated, they too could be admissible. if that were to emerge over time.
Right. If there's reliable science gets to come in. It's just that unreliable science does not.
And without getting into too much detail, the expert, can it be a police officer?
I don't know. I know there's drug recognition experts, but I'm not confident that they really know enough about marijuana use and that the techniques that they're taught are actually scientifically validated either.
So what would the district court or BMC judge have to do? Would have to have a Delbert Lanigan hearing as to whether that person's expert opinion is admissible?
I guess they would have to determine whether that person was an expert, whether they had the foundational knowledge of how marijuana impacts a person's ability to drive and what physical manifestations are and what's the basis of their expertise.
So not as to the opinion itself, but simply as to the foundation.
Right.
And that's for another day.
Just one more, so that picking up on Chief Justice Gantz's last point before you sit down so we understand your position. So you would say that obviously the admission of use, the weaving, whatever other factors that are put in evidence in the trial, and that the prosecutor, assuming the judge finds that required finding is satisfied, the prosecutor argues why this is impairment, but that the police officer couldn't say, based on all of these different factors, that they are of the opinion that the defendant's ability to operate a motor vehicle safely was impaired by the use of marijuana.
No. Right, that's my position, that he
Okay.
could not testify to that.
Okay.
Okay, thank you.
Thank you.
Ms. King, good morning.
Good morning. May it please the Court. Michelle King, Assistant District Attorney for the Commonwealth. Before we get started, Your Honors, as I was doing my prep for this case, I realized that it's incredibly difficult to look at the studies and the way that they've been reproduced in the record. What I found more helpful was being able to look at them on my computer because they're in color and the graphs that are so important to understanding this issue show up better. So I'd like to offer, and I'm sure defense counsel would agree, that we could submit those by way of a PDF so that the court had a better ability to look at the studies. So if Your Honors would like that, I'd like to make that offer.
As long as it's been blessed by both sides.
Great, thank you, Your Honor. What is at issue here, Your Honors, is clearly not that a defendant who smokes marijuana is impaired to drive. That's been conceded by the defendant. Judge D'Angelo found that in his lower court findings. What is at issue here is what and how the Commonwealth can make out their case. And what I would suggest to you is that the field sobriety tests are one factor, one piece of the puzzle, if you will. What happens when a defendant is pulled over for suspicion of being impaired by marijuana? The defendant could have been weaving, the defendant could have been speeding. There are a number of factors why a defendant's pulled over. That too is part of the puzzle. What we need to look at here, Your Honors, is the field sobriety tests and whether or not there is a correlation between marijuana use and performance on field sobriety tests. Now, I would suggest to you, since 2014, when this hearing was held in the lower court, the scientific community has changed significantly, and as Justice Gaziano alluded to a moment ago, this is a field that is vastly developing, and just in the 2-year period between the time when the hearing was held in the lower court and when we were first here at the SJC and now when we're here again, the field has significantly changed. And what I would like to point out to Your Honors is this. What's most important when looking at the field sobriety tests and their correlation to marijuana ingestion is that the roadside tests are the best indication of impairment by use of marijuana and how they correlate to the field sobriety tests. And there are four investigations, if you will, Your Honors, that speak to the issue of marijuana impairment and a defendant's ability to, if you will, pass, or a defendant's performance on field sobriety tests. In those four investigations, one was from 2014, which Judge D'Angelo had the ability to look at, and the two defense attorneys were questioned on. The 2014 study was the Porvath study. However, since the hearing, three investigations, if you will, have come to light, and those I would like to suggest to you are the most important piece of information for Your Honors to look at this point. And so the three investigations were a large-scale investigation done by AAA, an investigation that was done by Hartman and Richmond, and an investigation which the trial judge did not have before him even once this issue was remanded, and I submitted to the court this week, which just came out in November of 2016, was the Decluse investigation. Now, all of those investigations involved defendants who were stopped for suspicion of impairment of some type, and they were all narrowed down eventually to drivers who were who had levels of THC in their blood only. They did not look at alcohol in their blood or other drugs in their blood, but simply that they had some level of THC in their blood that was confirmed by way of toxicology. Those, and if you look at just the 2016 studies, because they're the most recent, all of those studies showed a correlation between some level of THC in the driver's blood and poor performance on the field sobriety tests. And by
do with that at a trial. So basically, you're saying that there's enough science out there that indicates that marijuana impacts parts of the brain that control the ability to perform field sobriety tests. In one sentence, that's what you're saying, right?
Correct, Your Honor.
Okay. So then we know issues like reaction time, like perceptions, short-term memory, attention span, divided attention, all those issues might have some correlation to field sobriety tests. Does that mean that, that the police officer can get on the stand and say, based on everything I observed, I have an opinion that the defendant's ability to operate the motor vehicle safely was impaired by the consumption of marijuana?
Yes, Your Honor. Assuming that the police officer has some basic experience. So many of the cases, in particular some of the ones from the other jurisdictions, talk about a police officer having basic experience. So if a police officer has testified that they went through the academy and they had training in field sobriety tests and they had experience in a certain number of arrests, things like that. So the police officer has a basic knowledge, and we're not talking about rising to the level of expert knowledge, but a basic foundation of a police officer. A police officer may then testify, as they do in alcohol-related impairment cases, that these were my observations when the driver performed the field sobriety tests, and it is my opinion that the driver's driving abilities were diminished.
Well, let me just ask about that, because how is the police officer going to be able to testify to something that science has not verified?
Your Honor, much like in alcohol...
Well, science has verified the tests for alcohol impairment. We're starting from the beginning here, and I'm just puzzled at how police officers are going to be able to testify to something that the science hasn't verified. I mean, I don't get that.
Your Honor, what I'm suggesting to you is that at this point, science has indeed verified that marijuana ingestion or consumption does in fact correlate to poor performance on field sobriety
Well, that's
testing.
what you say, but the judge, the findings that we have in front of us don't say that.
Correct, Your Honor, and I would suggest to you that those findings are significantly flawed, and this is why.
But you're telling me that the judge didn't have this 2016 study available to him, right?
Your Honor, what I'm telling you is that there were two, so let me go through the timeline just a little bit for you. Maybe I can make it more clear. What Judge D'Angelo had before him at the 2014 hearing was a 2014 study by Porvath, and that study said that there was in fact a correlation between marijuana ingestion and poor performance on the one-legged stand test. So the one-legged stand test, and I think defense counsel conceded today, does correlate to poor performance, marijuana use to poor performance on the one-legged stand test. Then after Judge
marijuana use, I think. Correlated with marijuana use, I believe, not
Yes.
necessarily marijuana impairment.
Correct, Your Honor.
Okay. But there's difference.
Correct. The case then came here the first time, Your Honors remanded it. Judge D'Angelo opened the evidence in the sense that he did not have another hearing. However, he allowed each side to submit further articles with regard to latest studies. Two of the articles that the Commonwealth submitted, Your Honors, was a 2016 study by AAA and a 2016 study by Hartman Richmond that talked about the strong correlation between marijuana use and poor performance on field sobriety tests, including the one-legged stand, the walk and turn test, poor performance on the finger to nose test, and a number of signs that can be determined from the Romberg balance test. Judge D'Angelo had that information before him when he made his findings to this court on remand. What I'm suggesting to you, Your Honor, is that Judge D'Angelo, in fact, he said there were no studies that were submitted to this court that talked about any correlation between marijuana use and poor performance on field sobriety tests. And, Your Honor, that is clearly wrong. There were two studies that show a very strong correlation between marijuana use and poor performance on field sobriety tests. If you take out the investigation that I submitted this week, which Judge D'Angelo clearly did not have before him, but the two studies, namely the AAA study or investigation and the Hartman-Richmond investigation were submitted to Judge D'Angelo, and he had the opportunity to review those, and clearly he did not take those into consideration whatsoever. He made his findings, and his findings said that there were no studies that were submitted, and that's clearly wrong. So I would suggest to you that his findings are flawed for that reason.
So taken out of this context, were this another Daubert type of analysis? We have a trial judge who makes findings, and you're telling us that we should find that those findings are clearly erroneous and go the other way.
I suggest to you, yes, that the findings that he made were based on evidence from the hearing that he clearly did not consider.
How do we know if he didn't credit those findings? Because what I gather is if there were other studies submitted by defense counsel and the judge went the other way, like a lot of judges do.
Well, Your Honor, he didn't say I don't credit the studies submitted by the Commonwealth. He said there were no studies submitted, that there was no evidence in front of him, and I think I would suggest to you that that's a much different statement by the trial judge. I don't credit the the studies submitted by the Commonwealth is far different than there were no studies submitted, there was no evidence before the court, and that's clearly wrong.
What about the expert witnesses who testified?
The expert witnesses who testified, Dr. Richmond, who is the expert witness for the Commonwealth, testified that there's a correlation between marijuana use and performance on the one-legged stand and the walk and turn test. He testified that based upon his vast experience in the field, he's a DRE instructor. He has performed numerous roadside field sobriety tests. He testified that there is a correlation between poor performance on those tests and marijuana use. He testified that the main thing that field sobriety tests test for is divided attention.
And there was an expert on the other side?
The expert on the other side did not dispute that marijuana use impairs driving. He, in fact, said that there is a correlation between marijuana use and poor performance on the one-legged stand. What the expert for the other side, the basic thrust of his argument was there was no level of marijuana within the blood that correlates in the same way that alcohol level correlates to performance on field sobriety tests. And what I would suggest to you is this new data, this 2016 data, shows that regardless of the level of marijuana within the blood, anything above 1 nanometer of THC in the blood correlates to the same number of clues that have been found with 0.08% of blood alcohol levels.
Well, what he said was that the reason why he said there is no correlation is there is no agreement within the scientific community. I mean, I guess he's applying the Dalbert-Lanigan standard there to the evidence that he received. And the 2016 studies that you are talking about would just add to the mix of different opinions about this. It wouldn't be dispositive or conclusive.
Well, his findings were twofold, Your Honor. First off, he, in addition to what the passage that you just read, he said that there was no evidence before him. He then did go on to say that there was no agreement in the scientific community. What I would suggest to you is the important thing to look at is not field sobriety testing that has been done in the laboratory where a measured dose of marijuana has been given to certain study participants, and then they measure their ability to drive. When you look at roadside investigations that have been done, so drivers have been stopped for any number of reasons. In fact, if you look at the Hartman-Richmond study, the drivers who were stopped, over 70% of them had been stopped for some type of moving violation. So the drivers have been stopped, and they are then asked to perform field sobriety tests, and then a drug recognition expert has done an additional evaluation on top of the arresting officer. When you look at those studies, and there are 4 of them, and there have been no studies submitted by the defendant that talk about those type of roadside tests, okay? The only ones that have been submitted are Porvath, the AAA study, the Hartman-Richmond study, and now the Decluse study. Those are the only studies that have looked at roadside testing, and those are the studies that are critically important when you look at impaired driving and marijuana use and performance on field sobriety tests.
As I understand it, you're also disagreeing with Judge D'Angelo's findings that there's no inference that's permitted based on physical characteristics. of marijuana use, correct?
Correct, Your Honor.
And you would say that's just not true, based on what's out there with the science, whether it's bloodshot eyes, lack of convergence, eyelid trauma, drowsiness, dilation effect, all these speech, which goes to the temporal lobe. I even read in one study, yellow-green tongue, that if you take all of these things, that there's just no way that Judge D'Angelo's finding that there's no physical characteristics which permit an inference of impaired driving due to marijuana use is just wrong.
Correct, Your Honor. Again, when you look at those 4 studies that involve actual drivers out on the road who have been stopped, it's clear, the evidence is overwhelming that these defendants have at least some of the following signs and symptoms. Bloodshot eyes, over 70%, I believe in all of the studies that I just cited to you, the 4 studies, bloodshot eyes, eyelid tremors, dilation of pupils, all of those factors. And again, when you look at these factors, you're not looking at them in a vacuum. You're not looking at the field sobriety tests in a vacuum. You're not looking at the police officer's observations of the defendant in a vacuum. You're looking at the entire picture as it unfolds. Did a defendant admit to marijuana use? Is there a smell of marijuana in the car? Is there a bag of marijuana in the car? All of these things are, each one of them is a piece of the puzzle that you put together when a jury has to determine sufficiency for marijuana impairment.
Before you leave, I asked your sister about the world according to her, so let me ask about the world according to King. Officer stops a car, person leaves, stumbles, you of course say that comes in.
Clearly.
He wants to do the field sobriety test, you say that comes in.
I do.
Can the officer testify that he failed the test?
The officer can certainly testify that there are a number of clues that are looked at in the field sobriety test. Each individual test is different, but there are a number of clues that the officer looks for, and the defendant failed to perform X number of clues on that test.
So you can, in your world, the officer can make clear to the jury that this is being done pursuant to a particular test and that there are test variables which they should consider.
Correct.
Evidence comes in, whatever it is the evidence sufficient without there being an expert?
Correct, Your Honor. It's my, I would submit to you that an expert is not required in this case because, like alcohol, marijuana usage at this point is so widespread, it is in the common experience of a juror that an expert is not required to explain to jurors that if a driver is being asked to perform a walk-and-turn test and they cannot keep their foot on the straight line, if they can not follow the directions, if they take 5 steps instead of 9 steps, that you do not need an expert to explain that to a juror, because it is when the common knowledge of a juror that those basic functions in life, those observations of human behavior, an expert is not required to explain that to a jury.
And with regard to the so-called lay testimony of an officer, under Canty, you agree that if it was alcohol, the officer could not testify that the person was impaired by alcohol, that the driving was impaired by alcohol.
Correct, Your Honor.
The officer could say he was drunk.
Correct.
In your world, what can the officer say with a marijuana case?
In my world, an officer can say the exact same thing that they can use with regard to alcohol. And again, that's because he
was stoned, basically.
Excuse me?
He was stoned.
Correct.
But not that his driving was impaired because of marijuana.
Correct.
Okay, thank you.
Thank you, Your Honors.